All right, Tim Blanchip here with Divorce661's Daily Perspective, episode 12, Day in the Life of a Legal Document Assistant, or LDA. Today we're talking about a lot of stuff. Mondays are always busy, and here's what I got for you. We're going to talk about some changes with Ventura divorce submissions. We're going to talk about um, the 6 month and the processing time with them, talking about some LA County divorce cases as usual. We're going to talk about some e-filing issues, about finalizing your paperwork and the 30 days. Going to talk about why I like to prefer and always do file my cases at Central if you live in LA County. We're going to talk about preliminary disclosures. We're going to talk about what an actual default, what that actually means. We're going to talk about the judgment, specifically the property order and spousal support order. We're going to talk about Alameda divorce case and a judgment we just received about a default trial setting in Antelope Valley, and about a consultation I had with clients out of Santa Clara and the issues they were having with the self-help center. So this was all just today, folks. So we handle. I think when I say we, I'm just so used to doing that. But we refers to me, myself, and I. It's all done on my back. But a lot happened today. I want to go over all this with you guys and what's going on. All right, let's get started. Number one, submitted a Ventura divorce judgment. And so what that entails is with Ventura, we can e-file the initial petition, get a case number issued, but then everything else has to be wet signatured and mailed in to the court for review. And I reported on a short that last week I had a client ask for an update on the status of his judgment, because I told him or them that Ventura is running 4 months for judgments, and we had submitted this back in May. And I did the math. I said, yeah, we're about 5 months. That's right. So I called Ventura, and the clerk said that they're running about 6 months. Here we are, middle of October, and we submitted this in May. And so we're 5 months in, and they said they're not working. They're now working on the first week of May. So we still have 3 more weeks, and that's going to put them right at 6 months. Here's a tip for you on this. If you're in Ventura, and this is what we did for these clients, we usually get all our paperwork done much sooner than the 6 months, obviously, because you want to get your judgment in line for review. Let me give you a scenario here. So let me tell you what we did, and let me tell you what you don't want to do. What we did was did their initial filing, worked through they worked through their settlement, their disclosures, they did all that, got me their terms. We got that all drafted up. They were happy with it. They signed it. They mailed it in to me last week, all final paperwork, because today was actually the first day we could turn it in. So once the 31 days have passed, I say 31 instead of 30, just so I don't accidentally mail something in too soon. But once the time has passed and we can turn in the default judgment package, we want to do that immediately. Today was that first day. So I basically overnighted priority mail over to the court today, so they can get it probably Wednesday and start processing that. At least get it in line lined up to be reviewed. So we're now 1 month into their process from when it was filed and served, and then you're going to have this now 6 month review process with the court. Imagine now if we didn't turn this in for 3 or 4 months. It's going to be 6 months from that point, which would make the divorce case actually take 9 months instead of 6. And these clients really didn't want to go into anything beyond the 6 months. We want to get that in as soon as possible. So that's Ventura. Number two, my notes here, LA County divorce case approval took 5 court days. So once in a while, the e-filing with LA County, and we talk about this all the time, is fantastic. So I'm not complaining, but sometimes we'll get same day filings on our petitions. Sometimes it's 2 or 3 days. Sometimes we'll get same day approval on our judgments. Sometimes it'll be 10 days, which is still fantastic, not complain. This one we filed, took 5 court days. We filed it 2 Fridays ago, and got it back today, approved. So not too shabby. One thing I wanted to note about this particular LA County divorce case is I talk about equalizing your assets and debts on occasion. And this was a good example of that. I was reviewing the settlement agreement and terms that they agreed upon. And basically, the wife and her children from another marriage, it was her priority to stay in the house and not move and not sell. And in the agreement they made was that she would keep the house in the equity and that he would keep his pensions in retirement. And I'm sure they looked at the valuations of that, and they were, probably somewhat equivalent. And they decided, and they don't have to be, but they decided that, even if his pensions were worth more, it was more important that she kept the house. So she kept the house, he kept his pension, and I think that was both of their priorities. And so that worked out just fine. So you can equalize assets and debts. You don't have to divide everything down the middle. Plus, I always tell you, the courts are not going to interfere with your decision making. They're not going to take this agreement and then look at it and say, how much is the house? How much is the pension? We don't think that's fair. Come into court. They're not going to do that. All right. Number 3, I think we're on. File a new case today via e-file with LA County. Okay, so this was pretty cool. Again, talking about the e-file with LA County. We had clients consult with us on Friday, retain us this morning, and I was able to do their initial paperwork. They e-signed it, I e-filed it, and we had it. I got a case number issued. The petition was filed within the hour this morning. And because they had an easy case, no assets, no debts, no kids, short-term marriage, there's nothing to agree to. So we just are basically saying none on property, no assets and debts to divide, no alimony, all that good stuff. And I was able to prepare all their final judgment paperwork. They e-signed that, they e-notarized it. And I can't file that yet, but they are done in one day. Essentially, their entire divorce case is complete internally with my office. But now they don't have to worry about it. They don't have to worry about, what do I do this week or next week or what's the next step? They're completely done. And as soon as 30 days passes, or like I said, 31, I have their completed, notarized, signed, e-signed judgment already uploaded into the LA County portal for e-file. I mark on my calendar on this date, e-file this case. I already have it all uploaded appropriately. I just hit submit. And then once that judgment is submitted, usually it's a couple of days, like I'm saying, for judgment approval with LA County, and then they are done. The court will sign it. The judge will sign it. It'll be an official divorce decree. So 5 weeks in, they're completely done. And people ask me on some of my videos, but what about the 6 months? Yes, the 6 months still applies. So this case, they're actually going to be divorced, say, in April of next year, but they have their divorce decree in 5 weeks. And then what happens magically after that 6 months passes? It's going to be stamped on their form, on their judgment. And when that date passes, you are miraculously no longer married. I've commented often that I only file my cases always at the central courthouse. If you're starting with me new and you live anywhere in LA County, I'm going to file you in the central courthouse. You're not going to go to court. You're not going to have to drive down there. It's just they are more experienced. And so today, when I filed this case I'm referring to, they were just about at 11,000 cases filed. We pulled like 10,980 was our case number. The way all the courts do it in LA County is you'll have the year, so 23, and then for Stanley Mosk or Central, it's STFL, and then there's 5 numbers, and those 5 numbers, each case number is the next case number up. So I know that you can tell exactly how many cases there were. So I wanted to compare that to, say, Chatsworth, and I haven't filed a case in Chatsworth maybe all year. As far as a new case, we have people coming to us with their, they've tried to file and they need help. We'll take over. So we'll handle that in whatever courthouse they're in. So I tried to back in some case numbers to see where they're at. Just making up case numbers, and with Chatsworth, it's 23 CHFL. And then I was putting in like 1,500, 1,600, 1,700, trying to see. So I got up to 1,700, and it was a filing from 4 days ago in October. So 1,700 divorce cases in Chatsworth and almost 11,000 at Central. Yes, there's more clerks. Yes, there's more courtrooms, more judges, but I file there because they are processing cases. I don't want to say day and night, but we're getting better returns and better responses and better approvals through Central. And that's been my go-to. And I'm sure they're wondering why we handle so many cases, because I'll file on some days three new divorce cases, and they'll approve 2 judgments on at the same time. So anyways, I just recommend you guys file downtown. Okay. Preliminary disclosures are always required by both parties, even in default with written agreement cases. So default with written agreement, I talk about that a lot. It just means you're not filing a response. That way you don't have to pay the secondary court fee. But where people are going wrong with when they're trying to do their own divorce and they turn in their judgment package, they're not having the respondent or the respondent's not doing their preliminary declaration of disclosure. This is the 142 and 150, and then you file the 141 indicating that you have done that. They're assuming because the response wasn't filed that the disclosures aren't required, and that's not correct. You don't need to respond, but you still need to do your set of disclosures, and that'll cause your judgment to get rejected if you turn in a settlement agreement, default with written agreement, and no preliminary declaration of disclosure form for the respondent. So just keep that in mind. We're seeing a lot of people when they call for a consultation to help me take over their case. That's one of them, not the only reason, but one of the reasons why their judgment's being rejected. Okay, so I want to answer the question, what does the word default mean? I talk about default with written agreement, default without agreement. There's the request to enter default form, FL165. If you've been going through your divorce, you may be familiar with that form. The default, all that simply means is a response was not filed. Okay, simple. Default means response not filed. That's why there's default with written agreement and without. So just want to clarify that so you understand what that means. All right, next. Okay, again, more judgment rejection issues here that we had today. So we had someone hire us to take over their case. They said they turned in their judgment. They thought they were all the way done. They got to the judgment phase. And so the FL 180 literally says judgment on there. The form is called judgment. And it looks like it's all entailed there because you have, there's the day it was served. You go to page 2, child custody, child support, spouse support, property division, all that good stuff. You have to attach the forms, those orders in there to behind that 180. That 180 is not your actual judgment. I keep seeing this. People are turning in a 2-page form thinking it's their judgment. You have to attach all the attachments. But they get the question, but Tim, we don't have, there's nothing to agree to. We don't have any assets or debts, and we don't want there to be spouse support. Okay, perfect. So you still have to attach the FL 345 property order, and then on all the boxes for community property and separate property, you mark none. That's your agreement. You have no community property to be divided. And you still need a spouse support order, even if you don't want spouse support. And what you're going to mark is terminate the court's jurisdiction to award spouse support to petitioner and respondent. That's your settlement agreement. The 180 is a cover sheet. The 343 is your spousal order. 345 is your property order. And it's basically just going to say there's none. Okay, next. All right, where are we talking? Okay, so we just received approval today. Came in the mail of an Alameda County divorce case. We submitted it on September 1st by mail. Mailed it in, and it was approved October 2nd. And we just received it in the mail today, October 16th. So I'm bringing this up because I was actually impressed. I want to say this is the fastest we've ever had an Alameda County divorce case approved, basically in 30 days. That is lightning fast, especially compared to all the other courts, but definitely it's the fastest that I've seen, I think, in my 11 years doing this. So good job, Alameda. Our clients are very happy that this came back, basically 40 days later, count the mail time. Because some of these courts, they're not only are they slow in doing the actual approval. Let's say that takes 4 months, but we'll see cases that were approved by the court, say October 1st, not mailed out until the end of October. And I'd like to know, I used to know when I worked for the courts, but my guess is that you have an approval clerk, judicial assistant approving the divorce cases, then they're backlogged. And then that goes into another pile for the person who in the mail department has to then process that. So not only do you have a delay for having it approved, then you have a delay for them actually to put it into an envelope and mail it out to you. I'm sure some of the courts are also scanning them and keeping electronic files. And so there's probably some time involved with that. Okay, default setting, Antelope Valley case. Okay, so I was talking last week. We had a client hire us, and they had multiple 3 revisions, amendments on their petition. They've been to court. The default without an agreement. This is why I tell you don't do it unless the last resort. Multiple mistakes on the petition. Made mistakes even on his second amended petition. And I tried to sneak it into the court through e-file with Antelope Valley, and they caught it. What it was is that he didn't on the separate property declaration, he didn't say who this vehicle was going to. So the court said, well, this is wrong. You need to amend your petition, but we can't amend any more petitions. He's out of times that he can amend his petition. So I refiled the judgment package with what's called a default setting. And this is for LA County. Different counties have similar process. Maybe it's called something else, but a default setting is basically saying, don't reject this. I want to come in and explain sorry, I'm going to sneeze. I want to come in and explain what my rationale and why this should be allowed. So the good news with this was they accepted the judgment with the default setting, and they already set a court date for a month from now. So in a month from now, he could possibly be finalized with his divorce. All right. Next, I'm trying not to sneeze on you, but it may happen. All right. Next topic. I talk a lot about Santa Clara County. And the reason is because I have a lot of cases in Santa Clara County. LA County is number one. Santa Clara is number two. You think maybe a closer county to me, might be second busiest, maybe San Diego or Orange County or Riverside or San Bernardino, or maybe a little bit closer, but no, Santa Clara. And the reason is, in my opinion, they have the most challenging process to get your case through the court. And I think that's why, and I talk about them a lot. Every time I take a case, I talk about it. As in today at a consultation. And I want to explain a situation that I've never heard happen before. They were fully in agreement from the beginning. Filed their petition, did the proof of service. They've already done their disclosures. They've done everything. And then I guess they're going through the self-help center, and they said, oh, you need to go to a settlement conference. So they set them up for the settlement conference. They appear like a Zoom meeting at this conference last week. And the judge is saying, okay, why are you guys here? And they said, we were told by the self-help center to prepare to come to this settlement conference. And the court said, well, what do you guys disagree on? They said, nothing. We agree. We just need to have our settlement agreement drafted. They said, well, then you need to get someone to do that. You don't need to be at this hearing. So the short story on this, what I want to talk about here is you guys are at how do I say this? The courts are not always accurate in what they're telling you to do. They're used to working with litigants going through court, not amicable couples. So the advice you're going to get is always going to be, not always, but often going to be incorrect. I have another case that just came to the top of my mind where they were also going to the self-help center. They're telling them to file property declarations and all this craziness. You don't need to do that. Like with my service, we cut through. You don't have to go to a hearing. You don't have to talk to the self-help center. In both these cases, especially this one, they called me and said, yeah, you didn't need to go to the settlement conference hearing. We're just going to do the judgment and bypass the entire court process as far as their procedure, and just going to go past the judge to the clerk's office so they can review and make sure the I's are dotted, T's are crossed, and get it approved. And that's how that's done. And that's the benefit in hiring a service like mine than versus doing it yourself and trying to listen to the court. So I hope you enjoyed episode 12 of the Divorce 661 Daily Perspective, Life in the Day in the Life of an LDA. Talk to you tomorrow.